Hi, my name is Fernanda Salazar, and today I will be presenting Team Nine's Mythbuster project along with my team members Uma, Violet, Nathan, and Shalong. To begin, our myth was a business is not liable for injuries if a product includes a warning label. This myth reflects the idea that warning labels protect companies against lawsuits, and that once a business communicates its warnings, that it has fulfilled its duty of care. So why does this myth seem true? It is common for businesses to identify possible risk and to notify their users of these risks, which is why it appears intuitive that after warnings are given, their job is done. It is also appealing for business people to associate warning labels with immunity because of how simple the concept is. Additionally, it is reasonable to think that if a customer knowingly takes a risk, that they should be responsible for whatever negative outcomes arise from that situation. And lastly, warning labels are on products that we use in our everyday lives. Hence, why it's easy to think that companies solely rely on warning labels to avoid legal issues. Because of these reasons, it's easy to see why warning labels are viewed as legal shields. But these assumptions leave out important details which will be unpacked throughout the presentation.
All right, now we'll be moving into applicable laws for this myth. The first one being negligence, which can be found in Chapter 5 of Tort Law under the negligence section. So basically, a potential plaintiff may sue for negligence if they experience extreme physical loss, monetary losses, or even emotional distress. And that could be something like pain and suffering, for example. So in these extreme cases, a warning label might not be adequate enough to cover these injuries, especially if it is due to an oversight on the defendant's part. So in order to establish negligence, there are 4 conditions. First one is duty of care, which is where the defendant, aka the company in this case, has some degree to where they must care for and anticipate some sort of injury for the plaintiffs or for potential plaintiffs. The second one is breach, which is where the defendant breaches this duty of care. The third one is proximate causation, and there's 2 conditions for this. The first one is causation of fact, which is where the injury would not have occurred without the defendant's acts, thus making them liable. The second one is proximate cause. So this is when there's a clear link between the defendant's action and the plaintiff's injury, which again makes the defendant responsible. Fourth condition is damages, which is where the plaintiff suffered a legally recognizable injury, which can be any of the things that I've highlighted earlier. So evidently, the principle of negligence proves that complete immunity, even when there's a warning label on a company's product, is extremely unjust, because there's many special cases where, yes, there's a warning label, but still they have experienced some sort of loss due to a small oversight on the defendant's part. However, there is a gray area, especially in regards to defenses of negligence, specifically the assumption of risk, which can be found in the same section of this textbook. This is basically where the plaintiff is said to have voluntarily entered a situation even after seeing a warning label. The issue with this is that even small instances, for example, taking a larger dose of medication due to a faulty prescription error on a doctor's part, that also counts as negligence. So therein lies the question of, okay, is this issue due to the defendant's fault, aka negligence, or is it due to the plaintiff's fault, assumption of risk? For example, taking more of medicine to feel better. So these 2 factors are heavily considered in making a decision to see who has to pay damages. The third rule of law that I want to speak on is strict liability, which is when liability is imposed for reasons other than fault. For example, this could include abnormally dangerous activities like blasting dynamite. Just because you put up 100 warning signs does not absolve the company from still having plaintiffs who are suffering injuries from it. The second one is product liability. So manufacturers and sellers are held liable for harmful or defective products because they're the ones who benefited from the initial sale, and they can better bear the cost of injuries and damages.
Now, where might this myth fail? In this case, a company sells a portable heater. The heater has warning labels that says, "Caution, hot surface, do not touch." It also has a warning label that says, "Notice, do not leave the machine unattended." Now, the company knows that this machine is susceptible to tipping over easily as well as overheating. And the company knows that redesigning it with an automatic shut-off feature is possible, but they also know that it costs more money, so they decide against it. They also believe that putting these warning labels on the heater prevents them from getting any lawsuits. Now, given an example, a customer might use the heater normally in their bedroom and they accidentally tip it over. And then it starts a fire. And then they get injured and it causes property damage. Now, the company may still be liable because the product is still unreasonably dangerous and the company knew that safer alternatives existed. They also knew that warnings did not fix this defect. Now, courts often look at whether the danger could have been reduced through a reasonable design change. And in this case, adding a stability feature or an automatic shut-off feature would have significantly reduced the risk of injury. And even though the customer might have seen the warning label, the company might still be liable because they did not address the core issues of this product. And this just goes to show that warning labels are meant to supplement safety risks, not replace them entirely. So, businesses should not solely rely on the warnings, they should also have safer product designs and consider foreseeable consumer behavior. In this case, portable heaters are commonly used in bedrooms and small spaces, so the company should have known that accidental tipping is a foreseeable event. They also should have implemented this foreseeable event into the making of their product.
As for the application scenario, we have two characters, Susan and Bob. Susan runs a company that produces hydraulic presses. She puts warning labels on her products saying to not put anything besides the intended objects under the press while it is on and in use. Assuming this warning is enough to prevent her and her company from being liable for any injuries that users might get while operating this machinery, she decides to not implement any safety features such as a shutoff switch, as any of these features would greatly increase production costs. And as you know, more production costs would likely mean less profits, and businesses want to maximize their profits. And she starts rolling these hydraulic presses out. So now we have Bob, who is an individual that operates these presses on a daily basis. Although he knows that these machines can be dangerous, accidents can still happen. On one of his shifts, his mind was somewhere else, and he happens to rest his arm in the press while it is still running. So what happens is the press comes down and crushes his arm, and as there's no emergency stop button or any safety measure on this machine, the press goes down fully and completely flattens his arm, and there's no emergency stop. After this, Bob sues Susan for not having safety features on the press, arguing that there should have been, even though there were already warning labels. However, Susan argues back, saying that a warning label should have been sufficient and Bob should have been more careful instead. So here we see two sides. Susan, who runs the company that produces the press, simply put a warning label, however, with no safety features or anything, assuming that user knowledge and the warning labels would be enough. However, Bob, even with the knowledge and knowing there's warnings on there, still manages to get injured.
Now I want to talk about the business takeaway from our myth. A warning label does not automatically protect a business from liability. A good example is the Wyatt versus Levine. According to Cornell Law School summary of the case, Diana Levine was given a nostril drug called Vagana. The drug already had an FDA-approved warning label on it, but the warning label did not clearly explain the serious risks connected to the way of giving the drug, called IV push method. Levine was seriously injured and later lost part of her arm. The Supreme Court said that Wyatt is still responsible for the injury because the warning label is not strong enough. So even though a product had a warning label, it did not fully protect the company from liability. This case mattered to our topic because it showed that law looked at more than just if a product had a warning label on it or not. The warning label also had to be clearly explain the danger and harm. If it does not, the company is still held responsible. That is why correct rule matter in real business setting. Business cannot just add a warning label and assume they are safe from legal responsibility. If a company knows the product could seriously harm customers, they should take it seriously. Otherwise, they may face lawsuits, financial losses, and damage to their reputation. Because of this, decision maker should think about safety from the start. Instead of only asking, did we include a warning label on the product, they should also ask, is the product safe enough and is the risk explained clearly enough? A warning label can still be useful, but only as an extra protection on top of a safe product, not the only solution. Decision makers should also pay attention to complaints and injuries before the problem becomes worse. Ethically, I think this connects all the way back to chapter 3, the idea of more minimum. Business should do more than bare minimum required by law. If a serious harm is foreseeable and preventable, business had a responsibility to take a reasonable step to reduce the harm. In other words, protecting customers should matter as much as protecting their own business. And thank you for watching.